Well, I think most people have joined, so let's go ahead and get started. Welcome, everyone, and thank you so much for joining us. My name is Mosa Manesh, and I'm a professor of law and the associate dean for faculty research and programs here at the University of Oregon School of Law. And it's my pleasure to welcome you to today's Oregon Law Perspectives webinar. Our Oregon Law Perspectives series brings the work of our faculty to our colleagues, our students, our alumni, and the broader public. Today's session is the first in our summer series, and we're joined by Professor Garrett Epps for a retrospective on the incredibly consequential Supreme Court term that is wrapping up. Garrett Epps is a professor of practice at Oregon Law and teaches in the area of constitutional law. Before returning to Oregon, Professor Epps was a professor at the University of Baltimore Law School from 2008 to 2021. Prior to moving east, he taught constitutional law at Oregon Law, where he was the Orlando John and Marion H. Hollis Professor of Law for 16 years. He has also taught at American University, Boston College, and Duke University. While at Baltimore, he served for 10 years as the Supreme Court correspondent for The Atlantic, publishing more than 400 essays analyzing the Supreme Court's evolving jurisprudence and constitutional issues generally. He's currently the legal affairs editor of the Washington Monthly. His scholarship has appeared in prominent law journals, including the Duke Law Journal, the North Carolina Law Review, and the American University Law Review. Garrett Epps received his LLM and JD from Duke University and his MA from Hollins College. For more on Professor Epps, please visit our Oregon Law website and check out his faculty bio. The plan for today's webinar is for Professor Epps to speak for 45 minutes and then take questions. If you have a question, please feel free to use the Q&A feature at the bottom of the Zoom bar. Only Professor Epps and I can see your questions, and they can be anonymous if you so choose. We will gather them all and attempt to get to them at the end of the presentation. For those of you who are seeking CLE credit, you will receive an email after the event requesting your bar number so that we can report your attendance back to the Oregon State Bar. Now, without further ado, please join me in welcoming Professor Garrett Epps.
So thank you, Mohsen, for that generous introduction, and thank you to the Law Perspectives series for making me the inaugural speaker for this summer. I will confess that I am facing this webinar audience with more trepidation than usual because I haven't had any more time to look at these cases than you have. Three very important cases reached us at 7 a.m. Pacific Daylight Time. So I may be less self-assured in my judgments than usual. If any of my former students are in the audience, they will undoubtedly welcome that. And I may need to refer to my notes, and I may get mixed up about the names of cases, and I just apologize. I have spent every minute since 7 a.m. trying to understand this. And so what I'd like to do, I'm not sure, I don't want to take the whole 45 minutes if I can, because I anticipate really interesting questions about a very consequential term of court. We can't even do a retrospective on it because the court is now lapsed over into Monday for at least one of the biggest cases. I will go over the three cases that were decided today first. And I warn you that my understanding of the Chevron doctrine is not what I would call profound. I'm a constitutional law jock and not an administrative lawyer. I admire them, but I have some general observations about that case. It's clearly quite important. After that, I'll make a few general comments about this term of court and where I see the court headed, and then throw the proceedings open to questions. So with your indulgence, let me begin with the three cases that came down today. And for us in Oregon, the most local interest is the Grants Pass case, in which the court approved the Grants Pass ordinance, which is a very strict no camping ordinance, because it basically says that if you are sleeping in public with a blanket anywhere around you, you are camping, and this subjects you to a civil penalty, and if you do it twice, it's a criminal offense, and you can be charged with criminal trespass. One of the strictest anti-camping ordinances in the country, and the court, I think regrettably, approved the entire thing and just simply said the Eighth Amendment, the cruel and unusual punishment provisions of the Constitution have no application here. This is simply not applicable, so they're not leaving some limitation of the lower court precedent that held the Eighth Amendment applicable. They're not leaving anything of that. Interestingly enough, the opinion by Justice Gorsuch did say that there could be a due process challenge to these laws that make it basically impossible for people to remain in the city. And Justice Gorsuch, as I regret to say is his wont, engages in some pretty fancy juggling of the facts. And Justice Sotomayor, in an absolutely classic Sotomayor tirade, takes him to task about, just distorting the factual record, because it's very clear from the record that this so-called anti-camping ordinance is applied only to the homeless. That camping in public is an offense if you are planning to stay there and live there. If you have another home, you can sleep in the park, you can go out and spread a blanket and watch the stars. And this is all in the record. Interestingly enough, which I had observed going forward, and Justice Sotomayor calls out, the major players in homelessness, this case, the court says this case is being watched all over the West, which it absolutely is, in places like Phoenix, San Francisco, Los Angeles, Portland, Seattle, because California has something like 20% of all the homeless population in the country. So they're dealing in a very serious way with that. But the major players in that did not want the court to approve the Grants Pass ordinance. They said, we want more leeway. We want clear guidance from this court about what federal courts can do and not do to limit handling the homeless. But don't go all the way. And I infer that that's because they foresee that now there's going to be a great deal of political pressure in those cities. People are very, very concerned about the homeless situation. There's going to be pressure to adopt some fairly extreme measures that not only, are distasteful, but won't work. I mean, you can't round up the homeless in Los Angeles and ship them all out to Bakersfield. It's just simply impracticable. In Grants Pass, there are 600 homeless. That's quite a lot for a city of 38,000. But nonetheless, it's nothing compared to the numbers in Los Angeles and San Francisco. And they have now gotten, relief that they didn't ask for. This is a straight 6-3 party line vote. And we can now speak of the Constitution of the court as having a party line. And I will just finish my discussion of that by quoting something Judge Berzon, a college classmate of mine, wrote in a lower court opinion in this case, in which she found that the Grants Pass ordinance did violate the Eighth Amendment. She quoted the famous writer Anatole France: "The law in its infinite majesty forbids the rich as well as the poor to sleep under bridges, to beg in the streets, and to steal bread." Moving on from that case, we go to this case called Fisher. And Fisher is a statutory challenge to a provision of the Sarbanes-Oxley Act that makes it, it's a subsection of a section that makes it's called a catch-all. The section overall makes it a crime to destroy, mutilate, or conceal records. And this was passed in the wake of the Enron scandal, because federal prosecutors trying to get at the people who engineered the Enron scam discovered that there was no law against destroying the records. And so they got this law passed. It has a catch-all provision saying, or otherwise obstruct an official proceeding. So the question, which in a sense answers itself in my judgment, but the question is whether the January 6th rioters, by storming the Capitol and threatening the lives of police and members of Congress and breaking up the session of Congress, obstructed an official proceeding. And the court indulges in an opinion by the Chief Justice, which gives you an idea of how important he feels this is. The court indulges in some pretty fancy statutory tap dancing to say that Congress couldn't have possibly meant something like this. I find it utterly unconvincing. Interestingly enough, the dissent, which I find convincing, was written of all people by Amy Coney Barrett, who jumps off the constitutional wagon on this one and basically says, read the statute, Schmendrick. I mean, it's very elementary. But even, or not even more interesting, but equally interesting, Justice Ketanji Brown Jackson crosses the aisle the other way. She votes with the majority. So it's still a 6-3. This means that a significant number of the convictions of January 6 rioters are going to be subject to challenge at this point. Now, I hasten to add that it's not that it's going to swing the door open for all of these people, because most of them have been convicted on multiple counts. It will possibly lead to a lot of resentencing. And it's a very odd look for the court, which will tell us on Monday whether Trump is entirely immune from prosecution, to be stepping in and putting its thumb on the scales in behalf of the January 6th rioters. I tend to think that if those people had broken into the Supreme Court and threatened the safety of the justices, we might see a different result. And then finally, the big boy boomeroo of today is a case called Loper Bright. And this is a case about an incredibly obscure question of who has to pay fees for various government services, but was used to mount a challenge to the doctrine of National Resources Defense Council versus Chevron. And the court just goes flat out and says Chevron is overruled. Now, what Chevron holds is that when a regulation by an executive agency is challenged in court, the agency can come in and present to the court its interpretation of its own authorizing statute, because the idea is that the agency's in charge of this matter. It's been given this matter by Congress. They have expertise in this area. If they make a permissible construction of the statute, then the lower court, the court is supposed to defer to that. This originated as a somewhat conservative doctrine. Justice Scalia used it to say that the court should approve various Reagan and Bush era administrative decisions, but then it switched and became an article of conservative faith that we had to overturn the Chevron, because we have to dismantle, we have to stop this all-pervading octopus that they call the administrative state. I think that whoever coined that phrase is a genius, because what they're really talking about is the United States government, right? And to say we want to dismantle the United States government has a different ring. But this is going to have major effects in the lower courts. My colleague at the Washington Monthly, Peter Shane, who really is the best guru I have found about executive power, he says that to the Supreme Court, overturning Chevron or not doesn't really matter that much, because they've now generated so many doctrines that let them set aside agency issues that they don't really need it. The major questions doctrine, so-called, is the most important one. But what it does now is make every district judge in the country basically the arbiter of any given federal agency policy. And that includes Judge Kaczmarek, the guy who found that mifepristone should not be sold, who sits in solitary splendor in the Amarillo division of the Northern District of Texas, where all the agenda cases can be brought. And this is going to have to be slugged out. It's going to cause, I think, a lot of bloodshed in the lower courts. It's a straight party line vote. Justice Gorsuch writes the opinion. The opinion is utterly orthodox Federalist Society dogma. You could hear this explanation of what's wrong with Chevron at any Federalist Society panel over the last 10 years. We just have to deal with this. Is it going to cripple the ability of the government to govern? let's say we're taking a chance. There are three cases that aren't decided yet. One of them is these are two cases together, the net choice cases, which basically ask the question whether under the First Amendment, the state of Florida, the state of Texas can pass laws telling social media websites that they have to include conservative views, that they can't decide what to put on their platform, that the state will supervise that. It's a disturbing prospect. I certainly hope the court will apply orthodox First Amendment principles to that, but we will see. There is a case called Corner Post, quite obscure but important doctrine, which asks the question of whether, if you want to challenge a federal regulation, you have to do so within a certain period after the regulation is promulgated, or if a plaintiff can wait until the regulation impacts him and bring a lawsuit. And obviously, the latter is what is favored by a lot of conservative litigators. So we'll see what happens. And then finally, we have come to the H-bomb, and that is Trump versus United States. Will President Trump be, the Trump doctrine is I can shoot someone on Fifth Avenue and not only not use any voters, but I'm presidentially immune, even as a former president. And I anticipate, and this is cynical, but I'm going to go ahead and say it, I anticipate that we will have a ringing John Roberts opinion, in which he says, of course, America's a nation of laws, not of men. No one is above the law. We all, and of course, the president doesn't have any immunity from criminal prosecution, except this one teeny little exception. And we remand the case to the district court for extensive motion practice on that question that will safely carry us past the election. I think that one of the questions that is hovering over the institution is its apparent favoritism toward former President Trump. And that is illustrated by the fact that when Trump was being kept off a primary ballot, the court expedited the case with tremendous haste to make sure that they decided he had to be on that ballot before Colorado's deadline. But when Jack Smith asked it to take up this issue early, it refused. And that when the Trump team asked them to take up that issue after judgment in the lower court, they delayed 24 days, then granted cert, then set oral argument for the last day of argument. And they're now going to announce the opinion on the last day of the term. It just, this mysterious slowness set in. And that leads me into my theme that I'm going to say very as quickly as I can. But I think it's important. And I think it's important to understand we are living in a time of crisis, political and governmental crisis. American institutions are being tested as they have not been for many years. And we are seeing very serious signs of stress. It's perfectly obvious if you look at Congress, which really I don't think they would they could enact the Boy Scout oath if it was submitted to them. I think that that they're just so dysfunctional. But it's also true in the court. The court is affected by this. The court is showing a great deal of strain. We have an ethical crisis of the court. We have a crisis of apparent favoritism, apparent partisanship. We have financial crisis, deliberate flouting of financial rules, the kind of behavior that would have led to resignations or impeachments until very recently. Inside the institution is dysfunction as well. And the most obvious example of that is the leak of the Dobbs opinion in April 2022, which it was clearly done by someone with calculation. It was not an accident, but it caused a great deal of trouble. This term, we saw the leak of an abortion case that was just pure incompetence. And the interesting thing about the Dobbs leak is that the institution then proved absolutely unable to investigate itself. They announced that Inspector Clouseau was going to come to the court and just like find out all of this stuff. And they ended up with an investigation that said, well, we don't know. Somebody did it and it was not good, but we don't know who it is. And so uh, we have to be very aware, that this institution is almost in free fall, and that the path it is on is not sustainable. The fall in public regard for the court is going to lead to some change in its function, whether it wants to or not, whether Congress wants to do it or not. Over time in American history, the court has had its ups and downs. It may be heading for a down. Um, At the same time, the court will continue to operate and it will continue to follow the general policy. It is the general course it has been following since at least 2005, which is restricting the power of Congress to regulate the economy and public health and so forth, strengthening executive power in some areas, tightening the criminal law, and transforming the First Amendment into a tool by which the powerful run the country rather than one in which the powerless get to criticize um, what the government has done. And, with that, if you have questions coming in, Mohsen, if there are any questions, I'd be glad to toss it open, turn it open to them. And if people have specific cases they want to ask about, I've got notes on most of these cases, and we'll try to discuss them semi-coherently.
Well, thank you for that, Professor Epps. So now is the time. If you have questions that you want to pose to Professor Epps, you can use the Q&A button at the bottom of your Zoom bar to enter those questions, and I'll be the moderator of those questions and share them with Professor Epps. While we wait for those questions to come in, let me ask you a question. In the decision that overruled Chevron, I haven't read the opinion myself, but I'm curious, was there discussion in majority or dissenting opinions regarding stare decisis?
Yes.
Was it meaningful discussion? And as someone who doesn't labor in the fields of constitutional law all that frequently, I wonder, is there an overt recognition among the justices now that stare decisis is not a meaningful constraint on their decision making, or do they still pretend like it is?
The latter, they're going to tell you that stare decisis is like, whoa, so important. The section on stare decisis, which I read with a good deal of interest because that's something that I can vaguely understand, could have been cut and pasted and transformed with search and replace from Dobbs. You remember there's an extensive discussion in Dobbs about how Roe versus Wade was the worst decision ever, and who let these clowns on the Supreme Court? They ought to all be shot, and it was so egregiously wrong. Yada 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 yada. Alito, Alito, Alito. And the opinion in Loper Bright uses those precise same tropes in slightly more concise fashion. Justice Gorsuch is a clear writer, if somewhat leaden, and it just basically says there are factors that let you ignore stare decisis, and here they are: orthodox recitation, workability, poor reasoning, and so forth. And so we don't have to follow it. But of course, it's just like no one's above the law. Stare decisis is very, very important, very important. And but yeah, we really care about stare decisis. I think that claim runs more and more hollow as the court continues its what Justice Blackmun would probably call its slash and burn um, operation on precedent of which it disapproves. Have we got any questions, or have I stunned the crowd into silence?
Well, I'm not seeing any, unless I'm missing them. But I do have another question. While we wait for questions to roll in, you talked briefly about the disqualification case that was expedited and decided earlier in this term. I was a bit surprised in that case. That was a unanimous decision, a unanimous and unflinching decision in favor of former President Trump. I was surprised that there was not more purchase among any of the justices, including the more liberal justices, in the arguments that that there was an insurrection and that the insurrection justified disqualification. Um, but there's an instance where the court seems to have reached what I think we'd broadly describe as a nonpartisan decision. So how do you square that with the prediction you're making about the immunity case that's still forthcoming?
Well, there are two parts of that. First of all, although it was a unanimous decision, there is a very strong concurrence by the three liberal justices that says the court has done what it should not have done. And what they mean by that is that the court issued an useless, not called for, broad decision, that Congress has to enforce Section 3 of the 14th Amendment. And to be honest, I spent 5 years of my life studying nothing but the 14th Amendment, and I know the people, about the people that wrote it. I think it's nonsense. I think what they came up with is nonsense. But I think it was a decision impelled by, and this is why it was a concurrence, not a dissent, impelled by a recognition that if we start down this road where individual state governments can decide who can be on the ballot, it's going to be chaos. Because if you look at the map of the United States in red and blue, I think they'd be perfectly happy to keep President Biden off the ballot in Texas or Oklahoma, and California would be glad to keep Trump off the ballot, and we're not going to be able to have our presidential elections. We have a conceptual problem in presidential elections because they really are 51 individual state elections, including the District of Columbia, that are run under different rules and that are handled by the states. Now, in a certain way, that's a strength, because when you have a dispute about the vote in a state, the dispute is limited to that state. So that trying to, as happened in Mexico when people try to steal the entire presidential election by fiddling with the computers, that can't happen. But the problem is that it can also lead to chaos. And if you remember a decision called, as I recall, it was called Moore versus Allen. It was a case in which the state of North Carolina attempted to say that the legislature had complete control over selection of electors and could do anything it wanted, including, though it didn't quite admit this, up to setting aside the election and if it went for Biden, and proclaiming the electors for Trump. And the court would not touch that. The court just wasn't having that. And I think the same thing. This was sort of orthodox conservative doctrine about the independent state legislature, but the court just said, we are not going to contribute to chaos in the presidential election. So the two things seem to me to be connected and not entirely dishonorable. The interesting thing to me is how angry Justice Jackson got during oral argument in that case, because Trump's lawyer said, we're just going to focus on the text. We're not going to talk about the history at all. And Jackson goes into her kind of Tasmanian devil, because she actually really believes in a certain form of originalism, because to her, the 14th Amendment has, and I agree with this, some genuinely radical content that if we really tried to apply in line with the general understanding of the framers, would produce very different results than we're seeing. And so she basically said to this guy, we hear nothing from you people except original this, original that, except now the original stuff favors me. And suddenly you're just like, oh no, we only want to talk about text. That was a really interesting moment if you listen to a lot of oral arguments, as I do.
Thank you. So we have a few questions coming in now. A couple about
Good.
the EMTALA case. Um,
Yeah.
one question: Justice Jackson said in her opinion that it was ripe for review. Do you agree? And a related question: now that it's been remanded back to the lower court, what do you think is likely to happen at the lower court?
Well, first of all, yes and no. In other words, was Justice Jackson right? Well, she's right in this sense. The court had decided it was ready for review. The court aggressively reached out and took this case away from the Court of Appeals to decide it right away. And then this bizarre opinion in which it says, it's what's called a dig, which means dismissed as improvidently granted. It's like, we shouldn't have granted cert in this case at all. And we're remanding it. Now, first of all, again, we talk about the institution and its competence. Are you really saying you didn't read the papers? Right? You're like, oh yeah, we'll grant this extraordinary review. Oh my God, this is a case about EMTALA. I didn't know that. We'll remand it. Of course not. Of course not. That a judgment was made by the court that it was ready to be reviewed. And subsequent to the argument, the majority says, well, we've decided there's not as much conflict between Idaho's law and the Emergency Medical Treatment and Active Labor Act as was first represented. So we don't have to decide this. In fact, we should just remand it and leave the injunction in place forbidding Idaho from enforcing its almost total ban. Now, the difference, just for the record, is that the EMTALA, the federal act, says that if someone is in labor or if something is going on that threatens their health, an emergency room has to stabilize that person. And there are occasions when serious health effects can follow from continuing a pregnancy on an emergent basis. And so under EMTALA, it says any hospital that accepts federal funding, which is every hospital, has to provide that treatment. Under the Idaho law, they've been airlifting people like that out of the state, as many as one a week, because this is something that happens to women that have pregnancies go wrong and need to be treated right away, or the result is terrible compromise to health, loss of fertility, loss of a uterus. Idaho says you can only do that if the death of the woman is imminent. Otherwise, you have to let nature take its course, which is kind of shocking, if you think about it from some remove of time. So the question is, how do we resolve this conflict? And the court then says, well, from stuff that was said at oral argument, the conflict is not as great as it should be. And the dissent says, what are you talking about? I mean, some guy gets up and flaps his gums in oral argument. That's not a binding legal concession by the state of Idaho. That's just gum flap, right? And the second thing to realize is there are other states with identical laws. And the original guidance from the Biden administration said EMTALA requires you to provide this care. Those other states have also refused to do it. And in the more conservative circuits, they've been upheld. So what that means is, because the headlines all say Idaho's law can't go into effect. Well, that's right. But Texas, Oklahoma, other places where pregnant women are encountering real health problems, these laws can be affected. EMTALA is being effectively nullified. And the final thing to realize is when the court, and those of you who have read about or studied the shadow docket, I think know this, when the court engages in one of these extraordinary orders, like what was called cert before judgment, where they reach down and take the case away from the Court of Appeals, that can only be done with 5 votes. 4 votes to grant cert in the normal course of things, 5 votes to issue one of these extraordinary orders. And if you look at the case, there's a case called Holder versus Ken, that has the factors the court is supposed to consider when deciding whether to grant these emergency relief measures. And one of them is likelihood of success. Well, what that means is 5 justices voted at the time that cert was granted. They voted that Idaho was going to win. The court tips its hand with this order. So I think what's very likely to happen is that this case will be consolidated with the challenges in the lower courts. It will come back, and there's a very good chance that this court will hold that these laws can go into effect. Now, They did. I mean, I'm sure this is just a coincidence, but it did have the effect of meaning that on the day of the presidential debate, um, there weren't headlines saying Supreme Court says pregnant women can die, they don't care. Instead, it's like Idaho law can not go into effect. I'm sure that's just a coincidence, but that's the way it happened.
Thank you. There are a few questions coming in about the grants pass decision. So let
Sure.
me pose them. A couple of them relate to the same issue, but one of them deals with what's going on here in Oregon specifically. Not to diminish the grants pass decision, but now with ORS 195.530, which requires that any regulation be objectively reasonable in time, place, and manner to sit, sleep, or keep warm on public property. Does the court's decision today change much for local governments in Oregon? Um, Given that the state limits what municipalities, what localities can already do by placing this objectively reasonable limitation through state law, does anything in the court's decision change what localities or municipalities can do in Oregon?
The court goes into this in the decision, and the answer is that the Oregon statute has not been definitively interpreted by Oregon courts. Obviously, the grants pass ordinance, having passed federal constitutional review, will now be challenged under this statute. And, I frankly don't see how the Oregon appellate courts can uphold it. It is just such a wretched law, in my view. But I'm not a judge, and so it is very possible, in fact, quite likely, I think, that the grants pass ordinance will not go back into effect because it will be enjoined by an Oregon state court. So the effects of this law will be felt elsewhere. And, one of the downstream political effects is going to be whether it's hard for states to enact laws like the Oregon law that provide a floor for what cities can do. Because, you say to people, we can do anything you can do anything you want. That's the message that's given. It's very hard to close that door. People get very excited about it. I think that it answers the question, but it's a very important point.
A couple other questions related to the conduct versus status distinction that comes up in the decision. One asks, did the grants pass case on homelessness deal with the precedent that distinguishes between conduct, for example, drug use, possession, versus status, for example, being addicted? That is, did the court say homelessness is not a status, but is conduct, hence not protected under the cruel and unusual punishment prohibition? And relatedly, another participant asked, the court allows imposition of fines and periods of confinement for conduct, for example, camping. The court rejected the status argument that homeless have a status like in the Robinson case, and Justice Thomas even goes so far as recommending Robinson be reversed. Did the Ninth Circuit go too far in expanding Robinson to the homeless population? It seems like the court today said so.
Well, there's two levels to that, and I'll tackle the last question first. The Ninth Circuit opinion precedent, which is Martin versus City of Boise, as I recall, is the name of it, actually had a great deal of went to some length to provide a great deal of leeway for cities to deal with. You can do time and place manners. You can do all kinds of restrictions that preserve health. Restrictions on criminalize using the park for a toilet, things like that. None of that, says the Ninth Circuit, is affected by this decision. Now, what happened in the wake of that, and I don't have the case sites, but it's on the record, is that a number of district courts issued fairly sweeping orders to localities about what they could and couldn't do, orders that seemed to go a good deal further than the actual Court of Appeals opinion. And so that's, I think, why these other cities wanted the court to clear it up. Because their basic view was we could live with the Ninth Circuit. We can't live with these district judges who are off on their own highways. And so there's a lot of question about the extent to which this case was needed. First of all, it's moot, arguably moot by the statute. I suppose it's not technically moot because it hasn't been interpreted. And secondly, it has to do with misinterpretation of a lower court opinion, not with the flaws in the opinion itself. Now, as far as the Eighth Amendment and status versus conduct, they make a couple of points. One is they basically say that the precedents, Robinson, I think, that says that you can't make it a crime to be addicted to drugs. That's what they said that precedent is cabined. It is confined to its facts. We're not going anywhere with that. They don't overrule it, but they say, that line of cases is, it's like Monty Python. This parrot has ceased to be. This is an ex-parrot. And then they say that the Grants Pass Ordinance is generally applicable, and that it criminalizes conduct. And this is where I feel Justice Gorsuch began to take some liberties with the facts, because in fact, the testimony in the record is incontrovertible that whatever it says in the language of the ordinance, it's only applied to the homeless. And they had testimony by law enforcement in Grants Pass that said, well, the law says you can't be out in public with a blanket. And they said, well, but we would never enforce it against people having a picnic or stargazers looking at the sky, because they are not making it their home. They have somewhere to go. So it's, in other words, it in effect only criminalized homelessness. And that is that really a regulation of conduct? Basically, Justice Sotomayor says, saying that people can't be in public and sleep is like saying this is conduct. We're not regulating the status of being homeless. We are regulating being in public and breathing, and that's conduct. That is how she kind of ridicules that distinction. The idea that homelessness is a status met with a lot of pushback from the justices at oral argument. Chief Justice Roberts said, well, what about being a bank robber? Is that a status? This is the view of homelessness that is had from the lofty perch of the Supreme Court. So, I think that the Eighth Amendment is now a dead end. I do think, I think there's a lot of due process questions about criminalizing behavior that people can't avoid doing. And I'm sure we're going to see a lot of litigation about that as we go forward. It's going to be very interesting.
Let me follow up on that since you brought it up. One of our viewers asked, can you talk about the court's penchant for ignoring or distorting the factual record developed by the district courts, and how that may impact the development of factual records in district courts and/or its consideration by the circuit courts?
I think this is a wonderful question. And I think that it becomes most interesting in the area of direct appeal to the Supreme Court of 3 judgments made under the Voting Rights Act. And as you recall, there was a case from Alabama, I think it was called Allen versus Milligan. And it had to do with the decision by the Alabama legislature to come up with a congressional apportionment that really minimized the strength of a fairly compact Black community. And, by chance, that was going to mean more Republicans, fewer Democrats in their congressional delegation. And this case was decided by a 3-judge panel who heard extensive testimony. They had 27,000 pages of record, as I recall, live testimony, documents, and so forth, and decided, as findings of fact, that this was done to minimize Black voting strength. It violated the Voting Rights Act and so forth. The state of Alabama took an emergency appeal to the Supreme Court, which put that judgment of the 3-judge court on hold. meaning that the 2022 election was held under a apportionment plan that had been adjudged unconstitutional. The court did not decide. Then they heard it and they affirmed the order of the district court. So that is a kind of odd attitude toward, hundreds of pages of factual findings. And now in another case that's come forward from South Carolina called South Carolina NAACP, in an opinion by Justice Alito, and if you're in favor of voting rights, those three words are, make your blood run cold, that basically says, well, yeah, they put all the Black people over here, but that was a coincidence because they were really just trying to be partisan and put Republicans give Republicans an advantage. The court has approved that in a case called Rucho versus Common Cause. Partisan gerrymandering is now, it's open season on that. So I think that, these three judge panels, they work very hard. And the one in the Alabama case, at least two of the judges were appointed by Trump, right? So it's not like these rogue liberal judges down below wreaking havoc with precedent. And the court is going where it's going. It doesn't care about the facts. I mean, they want to decide limit civil rights protection for gays. So they take a case in which she says, oh dear, I might go into the wedding website business. And if I did that, a gay couple might come and ask me, and then I might get in trouble with the Civil Rights Commission if I said, and they said, oh yes, you poor thing. You're being so terribly injured by this daily terror that you live under, right? Or they have a case where they say, the football coach was fired for quietly praying, himself and his God after a football, in a quiet moment of reflection. The pictures, which Justice Sotomayor included in her dissent, show what really happened, which was having spent the week before this publicizing what he was going to do, the football coach attracted many, many members of the Washington state legislature, TV camera crews. They knocked over the marching band to get to him and pray with him. But Justice Gorsuch says, oh, the still small voice. And then they said, and he was fired. And he was fired for this. He wasn't fired. He didn't sign his contract for the next year. And it turns out he's now a popular speaker on the conservative circle, so he doesn't need to. He came back and they said, Coach, are you coming back? He said, why would I do that? Why would I coach for you? I'm more important than that now. So you can see that the facts, that they're going somewhere. This court is going somewhere. They have an agenda. They've assumed almost complete control of their docket, and they're going for what they want, and they want to get it done while they have this supermajority, and they're not going to let facts stand in their way.
A contrarian question, not necessarily a contrarian question, but a question about some contrarian votes in the Fisher versus U.S. case, the January 5th obstruction cases. What was Justice Jackson and Justice Barrett's rationale for crossing quote party lines in their votes in that decision?
I don't know about KBJ because I don't think she wrote separately in that case. Justice Barrett Justice Barrett is more and more the most interesting justice on that side of the aisle. She's just about the only one of these guys who didn't get on the court by toadying to the executive, by working in the Office of Legal Counsel or being working in the White House. Kavanaugh was in the White House in a non-legal post. He was the staff secretary. Thomas was head of the EEOC, appointed by Reagan. Roberts was Solicitor General. These were people who made their bones, so to speak, serving the executive and the desires of the conservative executive. Barrett didn't do that. She went into, she clerked. She was clearly the most brilliant student in the history of Notre Dame. She clerked for the Supreme Court, practiced for a couple of years with a private firm, and then went back to South Bend to be a professor. She doesn't seem to be overawed by uh, the movement, the conservative movement that has embraced her, and they're very angry. They're very angry at her today. You look at Twitter; it is just blown up because of this vote. But I just think she's very interesting. I mean, she wrote the dissent in one of the environmental cases, the Clean Air Act case, where she said, I don't know what you guys in the majority have been smoking, but the statute you're talking about bears no resemblance to what's actually on the table. She kind of believes what's really written on the page, and it's going to be really interesting to see whether she develops this independent streak or ends up, being absorbed back into the Borg of the right-wing majority. Justice Jackson has clearly got her own ideas about criminal law and criminal practice. And she, I think, thinks that the statute in question, the Sarbanes-Oxley provision, is not well drawn. It is vague. It should not be used to take people's liberty away. God bless her. I'm not sure I agree, but it's a genuine legal discussion. Ketanji Brown Jackson is a serious lawyer and a scholar of the Constitution, and my hat's off to her, and my hat's
Just
off to Barrett too. Just to be clear.
Just a couple more. We have time for a couple more questions, and I'll try to keep you on time to make sure we get to both of them. One of them relates to the shadow docket. Any thoughts on the use of the shadow docket this term as compared to other recent terms? Is it continuing to evolve? And relatedly, any thoughts on yesterday's shadow docket ruling in the EPA interpretation of the Clean Air Act's good neighbor provision? Are advocates reading too much into the connection between Justice Gorsuch and his mother when it comes to the Supreme Court's interpretation of the Clean Air Act?
Um, I don't know how to tackle the mother question, because Justice Gorsuch, except when it comes to Indian law cases and a few immigration and criminal law cases, Justice Gorsuch is down the line federalist. You can almost not see Leonard Leo's lips move when he writes. And so that hostility toward environmental regulation is baked into the conservative legal movement. On the other hand, he does have a certain disdain, matching that of Chief Justice Roberts, for federal officials. He thinks they're jacks in office who come along and ruin everything. And he owned a ranch in Colorado while he was a judge, and who knows, maybe he ran into some officious BLM officials or something like that. But the mother thing is important. In her memoir, she discusses how he was the one who told her, Mom, you've got to fight. You can't let these people bring you down, blah, blah, blah. I wish I could say that Justice Gorsuch is an interesting character, but he's important but dull.
And any comments on the shadow docket?
Well, I do think that the shadow docket is there. I don't have the numbers for its use in this term, but I do think we've seen two cases. You mentioned the Clean Air Act case and Moyle, the Idaho case, where the court used the shadow docket to grab the case away from the Ninth Circuit, and in the process would eliminate what was undoubtedly going to be a precedent striking down, saying EMTALA did apply, right? They took that, that never got written because they took the case away. And now they're saying, oh, we made a mistake, sorry, big deal, I forgot. And that's just not an appropriate use of the court's docket and jurisdiction. So I think this is an ongoing problem. And a lot of it, does happen below the surface. But one of the things that the conservatives do is use shadow docket orders denying certiorari as a chance to signal. They'll write, Alito will write an opinion, Thomas will write an opinion saying, gee, wouldn't it be interesting if somebody brought us a case that argued that? I don't know what would happen, but boy. And the court tipping its hand like that is improper. They're basically lobbying the circuit courts, saying we're going to come after you if you decide it the other way.
Yeah, it strikes me as another way in which the court is getting to set its own lawmaking agenda, right? It's not just choosing specific cases, but
Yeah,
kind of tipping its hat
yeah,
as to what kind of cases it wants to see. Um, w-
yeah. Let me just
w-
figure out by saying you should read Steve Vladek's book, The Shadow Docket, our questioner. It's a wonderful book, and it really lays out the stakes going forward, and you'll understand it a lot better. I didn't understand it until I read that book. Go ahead. I'm sorry.
Last question, and we have 3 minutes for it. Any bright spots for you in the court's decisions this term? Is there any cause for hope or optimism going forward?
Well, optimism. The man who laughs has not yet heard the terrible news. So I'm not going to subscribe to optimism. But I do think the Rahimi case is a fascinating case. I teach a seminar in originalism. That case is going to be the first case that I teach, because in that case, 8 justices of the court took originalism away from Clarence Thomas. And they said, that's not the way you do it. We do it in a way that's going to allow some reasonable gun regulation. Thomas, Thomas, the author of Bruin, writes The Sole Dissent, saying you people don't understand anything. What it means is that we're not going to have domestic abusers armed to the teeth running around the landscape. And I think that's something to be glad about. Optimistic? I don't know. Glad? Yes.
Okay. Well, with that, thank you so much, Professor Epps, for sharing your analysis and leading this fascinating discussion. And thank you for everyone who tuned in. Thank you for your questions. We hope you will join us for our next webinar in our summer series, which will be on August 16th, when Professor Howie Arnett will provide us with a fascinating look at Apache Stronghold versus United States, a case that's currently pending before the Ninth Circuit and is poised to head to the Supreme Court, involving the protection of Oak Flat, a sacred site for the Western Apache and other native nations. We hope to see you there. Thank you again.